I realize neither one of you, I don't believe, Shane, you've ever interviewed with us, correct?
No, this is my first campaign.
And Linda has not. What we do, we've been doing these interviews for about 6 years now, both the primary and the general election. We'll probably be sending out our endorsement list on the judicial races for purposes of the primary in about 2 to 3 weeks. We will have one makeup day for other individuals who could not be present today. Once we send out the list, not only do we inform the individuals, the candidates I should say, but we also have email lists. I mean, the people at this table probably have, no hyperbole, in excess of 10,000 emails, addresses to send out this information to. We also get ad space donated to us in various Asian newspapers and periodicals where we list the individuals who we're endorsing for the various races. Historically, our endorsement picks have gone at about an 85 to 90% win rate, a success rate, be it at the primary or be it at the general election. So we're pretty proud of that. But we couldn't do that without candidates like yourselves coming down and meeting with us. So again, greatly appreciate the time you've extended to us. First thing we'll do is this, since we're unfamiliar with both of you. If you could perhaps give us 60 seconds, maybe up to 90, just a little bit of background on yourself and why you've chosen to run for Department B at this point in time. I've already informed the board that there is no incumbent. Judge O'Malley is retiring, well-deserved retirement, so there's no one from the bully pulpit to be chasing down. And we'll start with Linda because we're incredibly chivalrous here. So.
Thank you, I appreciate it. I'm Linda Marquis. I grew up here in Las Vegas. I'm a third-generation Nevada. I went to law school here. I'm the immediate past president of the Law Schools Alumni Association. Now I serve as a Justice of the Peace pro tem in both Las Vegas Justice Court and North Las Vegas Justice Court, an alternate judge for the city of Las Vegas. And last year, the Clark County Commission selected me to be a presiding officer for the New Corners Inquest of Police Fatality Fact-Finding Review Board. 2006, the State Bar awarded me an award for outstanding service to the community and my pro bono work in those areas. That's all about me.
Why Department B at this point in time?
At this point in time, it takes both of things that I'm really involved in, the community and my love for families, and my legal career, what I've been doing for the last 4 years. At the beginning, 4 years ago when I started sitting pro tem, I never thought I would be here, but I learned to love the job, and I do it quite a bit. I sit a lot, and I enjoy it. So it takes both of those things, my involvement in the community and my love for the bench, puts them together. So that's why I decided to run to Department B, and obviously it's an open seat, and that's why I selected it.
Thank you, Lynn. Jane.
I was brought here with my family in 1968. Been a long-time resident. Graduated from Advanced High School in '84 and then UNLV in 1988. I am currently sitting as the family court pro tem judge in the child support court. I've received commendations from members of the U.S. Congress for my family law pro bono services. I won the Louis Wiener Award for services to victims of domestic violence, all in the area of family law. I have been in private practice for 20 years, 16 plus, going on 17 years, primarily dedicated to family law. I chose, if I can go into your next question, the Department B. The reason I chose Department B is that I had been asked numerous times to run for office, and I've been told that we can use someone like you on the bench. I chose Department B because when I spoke, after allowing my wife to bless what I was doing and then talking to my partners, I started talking to my colleagues, and it was always all over the board. You run here, run here, run here. Department B was where I could get the consensus, and I believe the support of a large portion of the family bar is where I think my strongest asset would be, and therefore I took an open seat because there was no entanglements with judges that are presently on the bench.
Okay. The next question will start with Shann and then go back to Linda. The judiciary is somewhat of a mystery to most civilians. The only window they have into what it's like to be a judge and how to rate the judges amongst one another, amongst their peers, I should say, is the RJ's judicial performance evaluations that come out periodically. What ideas do you have to make that process either more transparent or more informative for the civilians, and by civilians, obviously I mean people who aren't in the practice of law. We know the judges, we appear in front of them, but normal people do not. What ideas do you have to give the public a better idea as to how to rate the judiciary amongst other judges, as opposed to, just amongst other judges?
Are you talking about how to make the RJ's process more transparent using that medium, or are you talking about in general how to make the
You can answer it either way.
Well, the RJs, it's very hard for the RJ to be transparent because a lot of people guard what they say in the RJ poll. My partner, Bruce Shapiro, has been kind of vocal, and sometimes he gets a lot of flack for what he says about some of these sitting judges, but he's as honest as he can be there. One of the things that I would point out is oftentimes the preemption rate of the judge is a better indicator than the actual approval rating, because the preemption rate is an attorney with a client making a monetary decision as to whether to preempt a judge. So sometimes the preemption rate is a better indicator of the respect or the confidence the community has in the judge. That's one indicator. I'm wondering, just off the cuff on your question, is perhaps having, every time we file a case, we have to sign a form, a case information sheet when we file a case. Perhaps at the close of the case, have the litigants file some type of evaluation. I mean, when we speak in public, we get evaluated as employees. We get evaluated all the time. I'm wondering if the public should indicate some type of evaluation sheet, 0 to 5, good on this. Did the judge express knowledge of family law? Did the judge have compassion? Was the judge knowledgeable, prepared? Did the court start on time? I think maybe that's a thought that has just come to me.
Okay. Linda.
I think that's a great idea, by the way. I also think the RJ's poll, if we as attorneys and judges could do more to promote it so that they had a much better feedback rate. Sometimes there's not as many lawyers reviewing all of the judges. I think that's important. There's also some interesting, in the last Ends of Court, there was a researcher from UNLV presenting information about the types of questions and their inherent bias. She has a lot of great recommendations and some good work, and I know she's forwarded those to the RJ. And I think they'll work together in the future to make sure that inherent bias, whether it be towards women or to minority judges, that be eliminated from the process.
I normally ask a question right after that, but I have to write down a note now because you're the first individual to bring that up. Did you want to say something, Ron, or
No,
you
I just
then I can write a note.
Yeah.
Okay. Linda, you've sat on the bench and practiced in civil and criminal court, and Shane, you've done a great deal of family law practice as well. And obviously, you'll have a chance to answer this question as well, Shane. But Linda, what do you see as the greatest area of inefficiency in family court? And assuming you're elected, how do you plan on tackling that problem?
I think it's time, and time in two ways. First, if you have a 9 o'clock calendar and it starts at 9, hopefully instead of 9:30, let's get the litigants and the lawyers out of there before 10. Let's set realistic court dates. I know we stack our calendars in civil, criminal, and in family court, but we need to do a better job of setting a realistic calendar. There's no reason for lawyers to wait and for litigants to wait 2-3 hours. The same time constraint as it relates to the length of the case. Child support, divorce cases should not take years. A trial should not have a day here and 2 years later we'll have a day here. We need to set those in a more concise manner and get our calendars under control to get people out of there more quickly. Domestic violence rates rise dramatically when there is a divorce case pending or a custody case pending. So it's imperative, especially in the family court cases, to make sure that matters resolve quickly. And I think that's the biggest hurdle facing family court right now that's easily resolvable.
Okay. Shane?
I think the efficiency is, when you're practicing in family law, you see people rise to the bench, and you see those that were diligent lawyers on the bench, and those lawyers, such as Bryce Duckworth, he has a filing a motion to a 30 days, within 30 days you're in front of him. Other judges are 45, sometimes 60. So it starts with diligence, and I think the first thing is to make sure that the judges, really the problem with the family courts boils down to, or any court, is the judge. That's the person that's processing the case. So diligence, and requiring the judges to be diligent, being on time, managing your calendar. Another thing is that some judges don't control their courtroom. Their 9 o'clock calendar bleeds into their 11 o'clock calendar because they cannot control the litigants in front of them, and it seems like sometimes in family court it's a knife fight, and that's unacceptable. Family court is treated like a stepchild oftentimes, and the lawyers get away with things in family court that federal court would never allow. So it's to respect the office, to efficiently work the cases, and get the litigants out of that process as soon as possible, because the longer it does linger, the worse it is for the families.
Do you advocate a more hardline approach, such as in federal court with deadlines, that if they are not observed, very, very bad things happen and oppositions are not considered? Or, because let's be honest, there are some judges who are on the bench right now who take more of a hardline approach, and they get absolutely lambasted every other year, I should say, in their ratings.
I tend to think when you're dealing with families, and when you have 60% of the litigants in front of you unrepresented, that you're going to have to allow for those parties not necessarily to adhere to the absolute letter of the rule. And also, I think as a practitioner, I've always thought that if I make a reasonable agreement with the opposing side to continue a trial for whatever reason, oftentimes it's to continue to settle, I think the court should allow that. I mean, not to let it linger forever, but I think that responsible attorneys need to be allowed. So I never really appreciated as an attorney when the judge says, well, someone's going to have to die before I continue this trial. It's not going to be continued, set in stone. I think that judge might have been too far away from private practice, because we, as lawyers, you need some flexibility, and you need to be allowed to litigate your case. But again, the flip side is the court needs to control that calendar. But I think that in some respects, the judges, in family court particularly, when you're dealing with best interests of the child, you can't just say, I'm not listening to this opposition because it was filed 2 days ago, when someone is requesting primary physical custody or a protection order. You need to hear both sides. You have to hear both sides. If it means continuing it, then by all means, but you can't just rule on the paperwork. That is not right for family court.
Linda, do you advocate death as a prerequisite for continuing a trial?
Well, I mean, even in federal court, we stipulate when the parties stipulate to continue a trial. I've never had a judge in federal court tell me that we couldn't do that. Now, I'm not saying on the 6th or 7th stipulation that it's appropriate, but certainly lawyers need time for a variety of reasons, and give each other that grace or courtesy to continue things if settlement is near. And that's important. So you have to allow attorneys that ability. There can't be, in cases though, where there are 2 lawyers, sometimes holding their feet to the fire is appropriate. Not in, scheduling a trial. But if there is an attorney who has been on a case and routinely his pattern of practice is to file his opposition the night before, at some point you have to draw the line in the sand. Now, if it's a mistake, or if he was just retained recently and all of those things, then yeah, let's give him the courtesy to give him some more time. And certainly you cannot take custody or final orders of the court as a punishment. We're going to give custody just because you didn't file your opposition on time. That's not appropriate. But you do have to and you see it in all areas of law when there's a lawyer who, or a firm or a group of lawyers who are consistently act as though they have never read the rules or understand the appropriate time to file motions or to be at court. There has to be some repercussion because there'll be no change in that environment.
Next question. We've gotten a lot of different answers on this one, but they all dovetail the same way. Linda, assuming you're elected, how would you avoid the appearance of impropriety with respect to individuals who may have disproportionately donated to your campaign?
Well, I think that it's important, and disproportionately. So, if somebody gave a couple $100, that's one thing. If they gave a couple $1,000 or a former partner of yours, or you're in other business ventures with them, I give that strict scrutiny. For many years, I did bar discipline defense. So I am intimately familiar with all of those rules and the practices of many of the judges in family court and criminal and civil judges, what their practice has been. I would err on the side of super caution. The problem is that you have a dual role. You have this duty to hear cases in front of you, and there are judges who have been disciplined for recusing themselves when it's not appropriate just because they don't want to hear that case. So you have to weigh both of your duties to avoid the appearance of impropriety and also to keep the business of the court moving along and hear those cases presented to you.
Okay. Shane, same question.
I was involved in the writ to the Nevada Supreme Court involving Bill Gonzalez, and we argued to the Nevada Supreme Court that $5,000 contributed by a litigant in front of that family judge was we didn't allege that it was something that would influence his decision, but we absolutely believed that it had the appearance of impropriety, and we asked Judge Gonzalez to recuse himself. He did not. We asked the Chief Judge Togliatti to recuse him. She did not, and we went to the Nevada Supreme Court, and the Supreme Court said that $5,000 was not enough to create the appearance of impropriety. I respectfully disagree with the Supreme Court. If you ask a multitude of anyone in the public whether $5,000 contributed by a party to a judge would influence their decision or has the appearance of impropriety, I believe that. I would have recused myself from that case if I were to receive, if I'm lucky to receive $5,000 from someone in front of me, I will recuse myself from the case, and if the Nevada Supreme Court puts me back on that case, then so be it. But I just tend to think that well, I disagree with not disagree, but electing judges is a tricky, difficult situation. So I guess that's my opinion.
You were the first individual who's brought up the name of the judge.
Yeah.
Well, I mean, it's public record.
It is public record, and I'm right when I knew you were coming in, I knew what was going to happen, but no one else did.
Was it the archery?
Hell no, it was mentioned
I read
earlier.
in the papers, yeah.
Yeah, it's been out there. Not everyone reads the papers
Sure.
closely, but I know you guys would have. Well, you personally would have a little more intimate knowledge of what
Sure.
went on. And
Sure.
anyways, that hadn't been said. That's why I was smirking through. As soon as I asked the question, Linda, I'm like, well, I know what Shane's going to say, more or less, on this particular issue. But it did bring it into the public consciousness, and it did cause some eyebrows to be raised throughout, civilians in general.
And it certainly was no disrespect to Judge Gonzalez. We never, ever alleged that he was actually influenced by the donation.
Yeah, and Judge Gonzalez does not have a primary. He does have a race, but obviously
Right.
he's not. Judge Gonzalez is not.
He's
involved
not
in
in
this
this race.
He's
Not
not.
in this race. Not in this race.
Yeah.
But we'll ask you for the judging.
Well, no matter who the judge was, I think it was an issue that's interesting and
Oh, yeah, yeah.
needed to be raised no matter who the judge
Yeah,
was.
I believe
Yeah,
that.
I
it was
agree with you,
recorded.
Mr. Shane, yeah.
Yeah.
I think the Supreme Court should have gone the other way.
I
It's my
agree.
gut feeling,
I agree.
personally.
You're preaching to the choir on
Yeah,
that.
yeah, you certainly
I
are.
said personal, not my group, it's just personal
Well,
opinion.
Do it a brown nose ahead of time, just in
Yeah.
case, Mike, huh? I agree. Anyway. Well, that's one thing we can talk about, maybe a little, somewhat briefly, because we're coming close to our time limit. The public in general doesn't have a great opinion of judges. You know, again, hearkening back to the rating the judges question that we asked, and let's be honest, this isn't a problem in your race, but in other family court races, the judges have left under somewhat ignominious circumstances. Assuming you're elected, Shane, what assurances can you give that you're not going to leave your electorate who voted for you holding their hands up in the air saying, oh, how did I elect that guy, and what the heck was that guy thinking? What assurances can you give that you're not going to end up giving another black guy to the bench in general?
The assurances, I can only say that I've been doing this for 20 years with not a blemish with the state bar. In fact, I am a member of the Nevada State Bar's disciplinary committee, and I've learned a lot from that. And one of them in particular is how I can't understand why lawyers do this when they're asked by a court to do something, specifically the Nevada Supreme Court, and they don't do it. And then they're brought up on disciplinary charges. And if it's not the Nevada Supreme Court asking them to do it, they get in trouble when they're not communicating with their client. I can't tell you how many times that the attorney gets in trouble because the client is saying, I didn't want to do this, but the attorney wouldn't communicate with me. So I kind of bring that to what I would bring from what I learned as a practitioner is being responsive to your client, communicating with your client, being diligent about your cases, prosecuting the cases, taking pride in your work, in your orders, and what it is that you do. And you can easily apply that to being a judge. The best judges, those with the 90% approval rating, the RJ, are diligent, they're responsive, they're knowledgeable, they're good to deal with, they got a great judicial temperament, and I believe that I have all of those qualities, and I don't intend to have an unblemished record after 20 years, take the bench and be brought off the bench for some nonsensical reason based upon my own inappropriate behavior. So that's the only assurance I can give you.
Okay.
I'm supported by a great section of the bar. The top criminal lawyers, the top former prosecutors, the top bankruptcy lawyers, they're all supporting me. Some of my fiercest opponents in the past, the people that I've gone head-to-head with, like David Roger and David Wall, are both supporting me. And I think that speaks highly of me, because those people that I fought with the most for the longest times, in the longest trials, are now supporting me and are very active in their support, and I appreciate that. I think that's a sign that they know me intimately and my ethical approach to litigation over the years, and they've decided to support me.
Perfect. Well, again, we're right up at